Good morning, everyone, and a very warm welcome to you all from what's a very sunny morning in London. Thanks for joining this webinar, which is the first in a series of 5 30-minute webinars that we're running over the next few weeks, over the next 5 weeks, in fact, exploring a number of themes on whistleblowing. So this morning we'll be looking at the EU Whistleblowing Directive and specifically discussing what impact it's likely to have on UK companies now that we're no longer a member of the EU. It's a topic that comes up in many discussions that I know I have with UK companies. So we'd like to share our perspectives and insights and also offer the chance for you to ask questions. So let's start with some brief introductions. My name's Andrew Breakwell. I'm Commercial Director for EQS Group here in the UK, where we provide a range of digital compliance solutions to organisations of all sizes. And I'm really pleased to be able to be joined today by one of my colleagues, Jens Gressler. Jens leads all the business development activities within the management team of the Compliance Cockpit, which is EQS Group's integrated platform for corporate compliance. And within EQS, Jens is the central point of contact around the EU Whistleblowing Directive and its transposition into legislation within individual member states. So Jens, thanks for joining me. Although we have a relatively short amount of time today, this is a 30-minute webinar, we'd really welcome your participation. So we've allowed time towards the end of this session to address any questions you may have. As any questions come to mind or comments come to mind, please enter them into the panel, which you should see at the bottom of your screen, and we'll get to as many of these as possible after the main discussion. If we don't get a chance to answer all of them, then we'll follow up with you individually after the event. And you'll also see on your screen now some of the other functions available to you on the webinar platform. I'm not going to go through them all in detail. I think most of them are self-explanatory, but they'll help you get the most out of this particular event. So I think that's everything by way of introduction. So without further ado, Jens, perhaps I could start by asking you to provide an overview of the directive and also touch on its relevance to UK companies.
Yeah, Andy, thank you very much for having me here. Really a pleasure. Good morning, everyone. Really interesting to see how many people we have on this webinar, actually, especially as we're talking about the EU directive, but at the same time having mostly a UK audience on the webinar. But this already gives some indication why the directive is relevant and has some effect on UK companies or subsidiaries of UK companies in the end as well. So maybe to just give some link to the directive. So what it is about, and where are we at the moment? So as many of you might know, the directive has been prepared within the EU over the past few years, and then more or less 2 years back, it was published, and there was an intermediate period that ended on the 17th of December 2021, so 3 weeks ago, actually giving the member states time to transpose the directive into national law. And so since then, it's in place, it's valid. You need to follow it. But it sounds more simple as it currently is, because as also some of you might have heard, transposition of the directive into national legislation has not been done by all of the member states. We can for sure touch this later on as well. But to make it clear in the beginning, so is it relevant for UK companies? Yes or no? I think the clear answer is, in most cases, yes. And if you just consider that you're either a UK headquartered company with subsidiaries, legal entities within EU member states, or you are a legal entity, a subsidiary of an EU headquartered company and based in the UK, the directive will affect you, and you have to deal with it. So what does the directive mainly cover? It mainly covers, so the scope is about speaking up, protecting whistleblowers that speak up and bring misconduct related to EU law up. So this is what it intends to do, and it provides vast protection, and it obliges organizations to provide different channels to speak up confidentially or even anonymously. So this is the core of it, and then there is a number of regulations around it. But before we enter into the Q&A part of the webinar, maybe one final remark to this slide. So even if you would be a UK-only business, would the directive be relevant for you and affect you? Maybe no. Would it be best practice to establish a speak-up mechanism, speak-up channels, and allow reporting? Probably yes. So I hope that everyone in the audience today will take some value from the webinar and from the following 4 occasions that Andy already mentioned. So yeah, Andy, back to you.
Yeah, Jens, you've touched on this a little bit already, and I'd like to explore it in more detail. But there's sometimes an assumption by the UK companies that I talk to that this isn't something that they need to do anything actively about, because we're no longer part of the EU. This isn't going to affect them as UK companies. You've touched on it in your opening remarks, but I'd like to explore that in a little bit more detail. So can we go into some detail about how this affects UK companies specifically, and what it is that they should be thinking about?
Yeah, absolutely. So the easy answer is if you are a UK company, but you have one or several legal entities larger than 50 employees in any EU member state, then you are affected. And what you will have to do is you have to establish and set up a whistleblowing mechanism, a whistleblowing system that allows your employees in these legal entities to speak up and to report on any breach or of EU law or misconduct regarding EU legislations. So it's as simple as that. You could even decide to say, hey, for my headquarter or any other country outside of the EU, I'm not doing anything. I will just do it for my subsidiaries within the EU member states. This is what you could consider. Would we recommend it? Clearly no. Because as I said before, it's best practice to have a whistleblowing mechanism in place. But to just comply with the directive, it would be sufficient to do this. Yeah. But as you can see, as soon as you have subsidiaries within member states, the directive affects you. Does that answer the question, Andy?
So what specifically should UK companies be thinking about, and what should they be considering implementing?
Yeah, that's also quite easy. So what you would need to implement in this case is you need to implement whistleblowing as a process within your organization, right? So there needs to be a whistleblowing function. Which would mean there needs someone being responsible for whistleblowing. This function should be as independent as possible from management, actually. So an independent position within the organization. Then you would need to establish reporting channels that would allow confidential and or anonymous reporting of employees or stakeholders around your organization to your organization, to the whistleblowing function, either in writing or orally, which actually is mostly explained to be a phone-based reporting channel. But to be clear here, the directive does not require you to offer both. So you could decide to just go with a web-based channel, and you would comply to the directive, right? It's kind of best practice, and EQS offers a number of options and solutions to address this. What else do you need to make sure? You need to make sure that within the whistleblowing function within your organization, there are people receiving the report, and only these people entitled to receive reports and communicate with the whistleblower have access. Yeah, so the privacy of the data, the privacy of the report and its content needs to be ensured. And you also need some documented procedures that ensure that within a certain defined time, so within 7 days you reply to whistleblower reporting. Within 3 months you give, if possible, a final feedback to the whistleblower about his or her report and the outcome and the measures he has taken. So there's some obligations around it. And clearly to also demonstrate externally that you're taking this serious and not doing just a checking the box exercise here. It will be important to communicate the existence of this mechanism, right? So establishing it, but not telling to anyone will not be sufficient. So you have to communicate it, that people are aware of the existence and know where to find it and how to use it and how they are protected when using it and speaking up in good faith.
Thanks, Jens. We're beginning to get some questions coming through, which is great. We'll get to as many of those as we can. Just a reminder, you can enter those in the panel at the bottom of the screen. There's one that's come up that I'll ask you now. This is, if you had a subsidiary in the EU with less than 50 employees in this location, would you still be impacted by the EU directive?
No obligation. This would just be a best practice decision.
Okay, thank you. We'll come back to some of the other questions a little later. Can we look at this also from the other perspective? Because I'm conscious on the session today, there are some companies with us today that are headquartered in the UK but have operations in the UK. So can we look at things from the other side? You know, what does the directive require of these companies? And again, what should they be thinking about?
Yeah, so in this case, the obligation is probably slightly stronger. So the EU directive would actually require these organizations to establish a mechanism throughout the organization. Still, you could argue and say we are not providing any reporting channels to any countries or subsidiaries outside of the EU. But the requirement is rather stronger. So if an EU headquartered company with a UK subsidiary should actually clearly implement a reporting channel within the UK organization as well, because in the end the sense of this and the idea behind all the directive is also to take care of consistency, right? So to establish kind of a standard across your whole organization, including all subsidiaries. But you have to differentiate between where is it really mandatory and where it is probably rather a best practice approach. Yeah. But more or less it's the same as I said, true. Looking from the opposite perspective, being an EU headquartered company with the UK subsidiary, recommendation clearly, yes, you should implement a reporting channel as well.
What about timings, Jens? Because as you touched on, you know, many member states haven't yet transposed the EU directive into regulations. So should companies be waiting until the member states have transposed the regulations, or should they be doing something now? I know that some companies are concerned that they may implement something now that they may be counteracted by local regulations that may come into effect.
Yeah, this is one of the really interesting points these days, because as I said earlier, the 17th of December last year, so 3 weeks ago, was a deadline to transpose. 5 out of 27 member states managed to transpose. So 22 are still lacking in national legislation. 20 out of these 22 have at least published a first draft or even a second or third version. So they are all in the process, more or less, of transposing, but it will still take some time. So there's two things to say about this. One thing is the question that you already raised, Andy. How should I behave? Should I wait until all of the member states have transposed the directive, or should I act already now? Clear answer is do not wait, because it's going to come anyhow. And the regulations and the requirements in the national legislation will, by 95%, be exactly the ones that are already in the directive, with maybe 5% option for national specifics, where the member states are allowed to maybe include already companies with more than 50 people now instead of in 2 years from now, right? Because there's another intermediate period that you might have heard. So currently it's become mandatory for everyone being 250 employees or larger. And in 2 years' time, it will be enhanced to the ones with 50 employees and larger. But some countries, like Portugal, for example, they have transposed it and have said once the national legislation comes into force by June 22, this will already directly affect everyone with 50 employees around. So, as I said before, don't wait, act now, because it's going to come anyhow. There's no reason to wait.
Jens, there's a comment that's just come in. I think it's important to clarify that if you're a financial services firm in the UK, you're impacted regardless of the number of employees. So thanks to Andy Noble for commenting on that. Okay, let's move on to questions now. There's quite a few coming in. We'll get through as many as we can over the session. The first one is around the channels for reporting. So is it correct that the directive requires me to establish both a call center and a web channel for reporting?
No, there's no obligation to establish both. There is only an obligation to allow reports either in writing or orally. But does this mean that you have to establish a call center solution? No. You could have a sufficient, highly secure, data privacy compliant web-based channel, and in addition, for example, a voice recording functionality for a whistleblower within this web-based channel, or even have an internal phone number someone could call. So there's no obligation saying you have to implement a call center solution.
Okay, and on a similar line in terms of reporting methods, if we design only an email reporting system where emails are available to be seen by an internal auditor or a non-ex board member and general manager at the same time, does this affect the neutrality of the reporting channel? So I guess the broader point is around email reporting.
Yeah, so email reporting is quite tricky for different reasons. One thing is that the directive makes it mandatory that only the people that are part of the whistleblowing function have access to the reports. Email is not a confidential and by far not an anonymous reporting channel, because at least your internal IT department will be able to access. So you need to be aware of it. And also, email allows it to quite easily even forward things. We all know it. You receive it via email, you click on forward and send it somewhere. This is different if you have usually managed by an external provider web-based reporting channel that is secure in terms of access rights, in terms of encryption, and so on. So email, if you only choose email, this will not be sufficient.
Thanks, Jens. We're going to move swiftly on to other questions, get through as many as we can. Are there any limits on anonymous reporting or whistleblower protection? So, for example, data privacy reports can't be anonymous, or only certain topics can be anonymous.
Okay, so anonymous reporting is one of the things that is allowed by the directive, but the member states have the option to further clarify this if they want to transpose it into the national legislation, yes or no. What we can clearly say from 20 years of experience with whistleblowing and also anonymous whistleblowing, this is absolutely best practice to provide an anonymous reporting channel as well. So a clear recommendation. There's studies showing that around 50% of the reports are made anonymous and would probably not be made at all if the option of anonymous reporting would not exist here. I would actually recommend that we do not go into details on the aspects between anonymity and data privacy here, because this would be a topic for a separate webinar. It's a very complex question.
Yeah, and just a reminder, next week's webinar, we'll be getting into some more detail on some of the specific requirements of the EU directive. Going on to another question here. If you received a complaint before the EU directive came into effect in a jurisdiction within the EU, does the 3-month time to provide a final response start on the date when it came into effect, or would earlier complaints not fall within this regime? Quite a specific question to answer.
Yeah, very nice. This is an edge case question, I would say. Not entirely sure what the right answer is here. Yeah, I think, like always, you need to be pragmatic. It's very clear when you received it after the directive came into force. That's very clear. Before that date, it depends on the legislation that is valid on that day in a country. And I would just, let's say, continue working on such a report and complete it and finish it based on the, let's say, old regulations, and then do the switch. I think nobody's gonna sue you for this if you handle it differently.
Okay. This is a relevant one given some of the services solutions that EQS provides. What if you already have a whistleblowing hotline that has been set up with an external provider, in addition to having internal channels to allow anonymous reporting? As the directive seems to state that whistleblowing reports need to be investigated and received internally, not externally.
So this is something we would need to look at in detail. In general, the directive allows also to have external reporting channels. But this has some specific requirements and regulations on how the internal function with the external service provider would cooperate. Yeah, so how the processes are really set up in detail. Nothing we can answer here very straightforward and easy. It's a case-by-case question.
Okay, and I guess as well, it depends to some extent on the nature of the services that your external partner is providing, whether they're just providing with the means of processing cases, or whether they're actually interacting with cases yourself. One of the questions that's come in is around how you can keep track of the transposition of the regulation into local legislation. I can answer this one, Jens. There's a very useful site called whistleblowingmonitor.eu, which tracks transposition into local legislation. If one of my colleagues knows how to do this, we'll paste it into the chat so you can have a look at that. But that keeps you updated on local application of regulation.
Yeah, let me just add to this. I can also recommend that you definitely subscribe to the EQS Compliance Blog, because we are also updating information on transposition of the directive there. And we are also going to try to have a kind of an overview, because what we see is there is a number of different sources on the web. Many of them are not really up to date, and some are even having different states on the same country. And we will try to sort this out as good as we can and share the information with you and others.
Okay, we've got a few minutes left. We'll try and get through a few other questions and then we can respond to others individually. Are the employee thresholds determined by individual company or assessed at a group level? I guess this relates to the 50 or 250 threshold for compliance with the directive.
This is by legal entity. Yeah? So it's not group-wide, it's per legal entity. Depends on your detailed structure here, but legal entity is the trigger.
Okay, there's a question here. I think we've probably got a chance for 2 or 3 more. Can the EU-based head office deal with the reports from a UK subsidiary? Or like the rest of the EU, does it have to be someone in the local company who receives and deals with these reports?
Very, very good question. In this case, the answer would clearly be headquarter can cover the reports from the UK because the UK is not a member state.
Okay, just to pick up on the website, I think that's now been pasted in, so the Whistleblowing Monitor link, and in the documentation that you'll see in the webinar, you'll see a link to our blog, which Jens mentioned, where we track changes into legislation as well. Let's try and cover a couple of others. Yeah, one of these we've already applied to. Yeah, how does this apply to the public sector, especially when they form the role of a designated organization?
Yeah, I'm not entirely sure what is meant by designated organization. Andy, do you know what this means?
No, I think this is one we'll probably have to take offline, Jens. So we'll come back to come back to that one. Yeah. Are there any regulatory requirements to report a whistleblowing concern to a regulator upon receipt, as opposed to when an investigation has concluded?
Can you repeat the question, please? Sorry.
Yeah, this is about the obligation to report a whistleblowing concern to a regulator if you're working within a regulated industry upon receipt of the report, as opposed to once you've concluded your investigation on a report.
Yeah, this depends very much on the specific regulation actually, and also the regulations that you have around this, right? So this might be different on a case-by-case situation. Hard to answer. This is probably something you should talk with a consulting law firm about, because it becomes very specific here.
This one is around understanding that member states have leeway to implement legislation beyond the minimum provisions of the EU directive. So how can organisations keep on top of or up to date with any additional provisions that member states implement? I guess in part those are the resources that we've already mentioned, which, as well as tracking initial transposition into local regulation, will also track presumably ongoing changes.
Yeah, absolutely. And just to give an example, so what we've already seen in the 5 countries that have transposed, and also seen in some of the drafts, is that where the EU directive requires you and makes it mandatory that you allow reporting breaches of EU law, the member states can decide, and some of them do already, that you can also report breaches of national legislation, right? So this is a typical enhancement that you will see. And as Andy said, follow the resources that we provide. Okay.
Jens, we're just about out of time. We've covered most of the questions. There are a few still outstanding, but we'll respond to those individually. So I think all that remains, hopefully we've managed to cover most of the key points and asked most of the questions that have been raised. Apologies if we didn't get to all of the questions. So I think all that remains for me is a couple of things. Firstly, to thank Jens for sharing his insights, and to thank everyone for participating in this event and for the questions you've submitted. I really hope you found the discussion helpful. And just a couple of final points. As I mentioned, this is the first in a series of 5 webinars we're running. The next one is on Wednesday at 11 a.m. UK time, where we'll be exploring in more detail the specific requirements of compliance with the directive. So we may get an opportunity to answer some of the questions that we haven't got to today. You can register using the link shown on the screen now. And we'd also really welcome your feedback on today's events by completing a very short survey, which again you'll see on the screen on the top right, I think. Your feedback's really helpful to us in shaping future events, particularly so as this shorter format is a new approach for us. So we're really interested to know whether it works for you as opposed to the sort of 60-minute formats that we typically adopt. So if you've got a couple of minutes to spend to complete that survey, that would be very helpful. So that's it for today. I hope you can join us next week. Thank you all once again for participating, and have a good rest of the day. Thanks all.